5 common mistakes to avoid when creating your California Revocable Living Trust. A revocable living trust is one of the best ways to protect your assets and ensure your wishes are followed. But one mistake could leave your family stuck in probate court or dealing with huge legal headaches. Many people think setting up a trust is enough. But if you don't fund it properly or choose the right trustee, it could fail you when you need it most. I'm Ali Talai, asset protection and estate planning lawyer and founder of Talai Law Offices. In this video, I will cover 5 common mistakes to avoid when creating your California Revocable Living Trust. Common mistake number 1 is not funding your trust. You could have a really good trust, but if you don't have your assets transferred into the trust or somehow connected to the trust, if something happens to you, there is still a great chance that your family and your loved ones would still have to deal with probate. A revocable living trust has the ability to avoid the probate process, the long and costly probate process, particularly here in California. However, it could only do that for the assets that are connected to it. So let's say, for example, you have a real estate, you have a property that you live in, and that property initially is under your personal name, and now you have created your trust. The second step to make sure we can transfer your personal residence into this revocable living trust, fund your revocable living trust with your personal residence, is that we need to make sure you transfer the ownership of the property from your personal name to the name of the trust. In most cases, we use a grant deed, and the grant deed will transfer ownership from your personal name to the name of the trust. Let's say you own a corporation or an LLC. In that case, what we want to do is we want to transfer and assign your membership interest in your LLC or your shares in your corporations into your trust. So now if something happens and you are incapacitated or if you passed away, the assets are considered to be owned by the trust, and it can avoid the long and costly process of probate. Common mistake number 2, choosing the wrong trustee. When we create a trust, initially, you will be the trustee of your trust, particularly these revocable living trusts. You are the grantor of the trust. That's the creator of the trust. If you're married, again, both spouses are considered to be the grantor of the trust. They're both, again, in most cases, get to serve as the initial trustee of the trust. If something happens to one spouse, the surviving spouse will be the sole trustee. And then when both spouses have passed away or don't have the ability to serve as the trustee, then whoever you appointed as the successor trustee will get to serve in that position. So where I say choosing the wrong trustee, I'm not talking about you. Hopefully you are the right trustee. But what I'm really trying to emphasize here is the person who you appoint to serve as the successor trustee. A lot of times I see people name their closest friend, their closest family member, or their oldest child as the successor trustee. And that might be fine. And in most cases, that is the person who gets assigned and who's appointed as that successor trustee. But the goal realistically here is that I want you to give this appointment more thought as it becomes really important who gets to serve in that position, particularly when you're not around. A lot of times I get to see family feud and lawsuits brought up just because the trustee that was appointed is not really doing a great job. This person who you want to appoint, we want this person to be financially savvy. We want them to have no issue and feel comfortable asking for help. They don't have to be a CPA, they don't have to be a lawyer, but we want them to feel comfortable asking questions, seeking the right advisors and the right legal assistant that is needed in the administration of the trust. And we want them to be a great communicator. We had a client that called us not too long ago, and the client wanted us to file a lawsuit against the trustee of their parents' trust to have this trustee removed. And when I asked, why is it that you want us to do that? She said, we haven't heard from this trustee in 6 months. We've sent letters, we've called, sent text messages. We haven't heard anything. So if this trustee would just communicate, would that act by itself would alleviate a lot of the headaches and a lot of the uncertainty and the drama and issue that could come up. So my advice to you is to appoint a great and responsible successor trustee in your trust. Common mistake number 3, not updating the trust after life changes. You've set up your trust and now something happens. You acquire, more property. You have a new child, grandchild. Good events, those are great, but unfortunately sometimes there's, a beneficiary passing away, a trustee passing away, a spouse passing away, divorce, those sort of things. These events will require at least a review, if not an update. And having these reviews and updates done right when the event happens becomes very important. If you have a joint trust and one of the spouses passes away, there needs to be a review of the trust, because in most cases, the trust is going to require the trustee, who again, in most trusts, is the surviving spouse, to do certain trust administration. There might be certain tax returns that would have to be filed. There might be certain documents that would have to be filed with the assessor's office. All these things are very time sensitive, so it becomes very important to make sure that you have the trust reviewed or updated by the right professional to make sure what needs to be done gets done. If you have a trust that provides for a specific distribution, so let's say you have multiple properties and you said child number 1 gets property number 1, child number 2 gets property number 2, and so on. If you have now sold one of the properties, or let's say a beneficiary has passed away, this is going to create some sort of an ambiguity within the trust. If the trust doesn't state what happens to that property if it doesn't exist, or if a new property comes to the trust, how does that property gets divided? So again, a life change or big events that happens in your trust will require you to do some sort of an update or at least a review. Common mistake number 4, not properly planning for incapacity. I have reviewed thousands of trusts, and most of them obviously have provisions to deal with what to do at the time the person passes away. However, there is not a lot of focus and planning in the trust for what to do at the time the person becomes incapacitated. Now, and I'm talking about mental incapacity. There are usually some provisions in there, but I'll show you or at least I will try to tell you what the problem is. So if somebody passes away, let's say we have a client who is, or there is a person who has a trust, and, let's say just a standard sort of a trust, and they're in the middle of escrow. The seller, who is the trustee of this trust, the property's owned by the trust, passes away. What escrow company would want, the third party dealing with the trust, what they would want is that they will want to see a death certificate that shows this person who was the trustee of the trust has passed away. Why do they ask for that? Because they need proof that the person who was in charge is no longer alive. So then the successor trustees of the trust, let's say it's the children, they can step in and be the trustee of the trust and sign the documents and have the transaction move forward. Let's say this person doesn't die. They have a stroke and now they are mentally incapacitated to move forward. Kids go to escrow and say, hey, we're the successor trustees of the trust. The escrow is going to say, well, I need some sort of proof that says your dad, your parents are not able to serve as the trustee of the trust because of their mental incapacity. It's not going to be enough for your kids to go there and say, my dad is not mentally capable of doing what needs to be done. My mom is not capable of doing what needs to be done. The third party that you're dealing with or your kids are dealing with now, they want proof. You passed away or the grantor has passed away, you provide death certificate. Now, when we're talking about incapacity, they want proof. So if there is a trust in place, you look inside the trust to see how do you substantiate that the person has passed away. And in my experience, in 3,000 and more trusts that I have reviewed, the trusts, most of them, 90%, 95% of them say you go to court, you get a court order that says acting trustee is not capable of serving as the trustee of the trust, and now the successor trustee can serve. But you could see the problem with that, right? I mean, the whole purpose of putting this trust together was not to go to court. And now we got a document that says something happens to you, you're incapacitated, go to court. And the problem with that is court proceeding in California, probate court could take a long time. And so you petition the court or the kids petition the court, and Judges are very smart, they're very educated, but they're not physicians. So then you have to go to a physician, get some sort of medical report, medical examination done, and then lodge the medical examination to the court, allow the judge to review this thing, and then come back with an order that says, okay, yes, the person that was serving as the trustee of the trust cannot serve as the trustee of the trust. Now the children or whoever that were named as the successor trustee of the trust could serve. This could take months. This could take like 3-4 months to get done. Imagine you're in the middle of escrow and there are not that many buyers are going to be willing to wait 3-4 months for this transaction to go through. Imagine the person owned a business, a restaurant. You're not going to have many employees that are going to wait around and work for months without getting paid. Usually there's rent to pay, vendors to pay, and all the other stuff. So you could see how this kind of incapacity planning that we're going to count on a court order will cause delay. So the way we handle it, and the way I think would be a much better way, is that in the trust that we create an incapacity panel. This incapacity panel, the individuals that get to serve in this incapacity panel are individuals that you get to select. Usually people select their spouse, children, brother, sister, parents, best friends, close friends, individuals and people that know them well, individuals and people that they trust get to serve in this disability panel. And what this disability panel can do is that collectively, if everybody on the disability panel agrees that the grantor or the trustee of the trust doesn't have the mental capacity to serve as the trustee, they can sign this document, notarize it, and that would be the proof that this person cannot serve. And now whoever you named as a successor trustee of your trust will get to serve. This is something that we've done in an hour. So instead of waiting 3 months to get a court order, if you have a trust that has proper incapacity planning, which is extremely important if you own a business, if you have a lot of real estate and assets within the trust, this would allow a much faster way to deal with incapacity versus the traditional option of going to court. Common mistake number 5 is outright distributions to beneficiaries. Every trust, it doesn't matter who drafted it, it doesn't matter if it's good, bad. At the end of the trust, when now the grantor or the grantors of the trust have passed away, you get into this lifespan of the trust at the end of it that says, how do you make distributions? And there are 2 options. Option number 1 is that the trust says you make outright distributions. So for example, you have 2 kids, distribution will go to kid number 1, kid number 2, it'll go under their personal name. So it will be kid 1, kid 2 as tenant in common if you have a real property that is being transferred to them. That's option number 1. Option number 2, we will actually create an inheritance trust. We will create a trust for each beneficiary inside of your revocable living trust. When? Right now that we're drafting the trust for you. These trusts are created. All the instructions of how to set them up and all those sort of things are written in your trust. They become effective at the time the grantor, the surviving spouse passes away. They spring into action at that point. And distributions will go out for each beneficiary inside of that trust. So each beneficiary is the beneficiary of his or her own trust. And also they can be the trustee of their own trust at certain age. So we could say when the beneficiary reaches age 30, 25, 35, whatever age that you think would be a good age, you kind of have to look back and remember how you were when you were 25 or 30 and figure out at what age you were better with finances. And that would be the ideal age to name in this trust. So we'll say at that age, the child would become the trustee of his or her own trust. It really doesn't make a whole lot of difference for the beneficiary as far as control and the ability to use the assets, because the reality of it is if they inherit everything under their personal name, they're in full control. If they inherit everything under their trust, they're the beneficiary, they're the trustee of their trust. Again, they still have the same availability as far as using the asset. The big difference here is if they inherit assets under their personal name, something happens down the road, they get into a car accident, they get it into a lawsuit, there is a divorce, they pass away. These sort of events, if it's just under their personal name, there is no law in California or United States that will say because this was an inheritance that the creditors cannot touch it. If they were in a car accident and the home is under their personal name and they're found to be guilty and liable for the claim, the creditor could take the home. So your inheritance, what you worked so hard, could be lost pretty easily because they got into some sort of a trouble or car accident or lawsuit or divorce. When you compare this to the other option, the inheritance option, at that point, if something happens down the road and there is a lawsuit filed against them, the creditor will not have the ability to reach into this trust and take the inheritance you left for them as part of their way to try to claim some assets and satisfy the judgment they got. It will be very, very difficult for a creditor to reach those assets. So it's realistically providing asset protection planning for your beneficiaries at the time you've passed away to ensure that your inheritance stays for them and for them to use only. We just dove into 5 common mistakes you should avoid when creating your California Revocable Living Trust. But how do you know you've taken the steps necessary to eliminate estate taxes and protect your estate from future lawsuits? Check out this next video where I will break it all down. See you over there.